Hi everyone, thank you for joining us. My name's Emily Clark, I'm Development Director at Highgate, and we are delighted to be joined on screen by Lawrence Kershen QC, who is going to be talking to us this evening. You may also be able to see on your screens Richard Brewster, who is our OC President. You will see at the bottom of your screen, there is an option for Q&A, and that's because Lawrence has kindly agreed to take questions at the end of his talk. Please feel free to ask them during the time that Lawrence is speaking, and you'll be prompted again at the end. And now over to you, Lawrence.
Thank you very much, Emily, and I hope I'm audible and visible, so away I go. And thank you to the OC Lawyers group for inviting me to come and talk. It's a rare occasion. In fact, it's the first time I think I've really been back to school, as it were. So a brief, quick overview of my legal and other work. I was called to the bar in 1967. I took silk in 1992. I became a mediator, I was accredited as a mediator in 1994. And in 1999, I left the bar, and that was the last time that I practiced as a lawyer. So I had something like 32 years as a barrister, but that was the last that I did. And I was thinking about how it was that I came to the law, and I think it started at the school in what I believe, what I know was the school library, which I believe was at the top of the science block then. I don't know, it may have changed, but for me, there was the library and the rule was silence. And one day, I was probably about, I don't know, 16 or something, one of the prefects started to penalize one of my friends for talking in the library. I knew he hadn't talked, and I remonstrated with the prefect to try to get his sentence, which was a PC in those days, maybe you still have them, a penal copy, to get his sentence reduced, or actually to get him acquitted. The prefect was one Michael Mansfield, who you will know, who was 2 years ahead of me. And I don't think I succeeded in getting him acquitted, but I think he might have got a lighter sentence. Anyway, somewhere along the line, I got the sense that I had a leaning towards advocacy and actually representing people who couldn't otherwise represent themselves. So I came to the bar, and I think it's worth saying that I wasn't particularly interested in the law, which is a strange thing to say, but I was particularly interested in what you might call justice. What that means is another question maybe we'll revisit. So I practiced at the bar. It was probably 20 years in that I started to get a sense of disillusionment. I was doing both civil and criminal cases. In my criminal cases, I was beginning to get the sense that the oppressed, who I had set out to defend, were often the oppressors, which was a bit of an alarming discovery, and that the victimizer was often a victim, him or herself. And that was a bit of a challenge for me. In fact, I resolved that by realizing that what I was doing was representing a system as much as the individual, a system where everyone has the right to a fair trial. And in my civil cases, I was seeing time and again that parties, even the winners, even my clients who won the civil cases, might say, you call that justice, as one of them did, because the victory was empty. It might be that the defendant wouldn't pay or couldn't pay damages awarded, or it might be that the cost of getting that victory was so enormous that effectively it was a Pyrrhic victory. So I was beginning to think there must be better ways of dealing with our disputes than this binary system, which is either on or off, win or lose. And it didn't seem to take account of the many shades, maybe 50 shades of grey that existed between the two extremes. So when someone said they did mediation, I was quite interested. He said he helped people to resolve their disputes without going to court. And I thought, my goodness, that sounds like a good idea, even if it spells poverty for the legal system. It certainly sounds good for the participants. So I started to explore mediation and discovered that it was, and I will quote the definition, a voluntary confidential process in which a neutral third party, that's the mediator, assists the parties to negotiate a mutually acceptable settlement of their dispute. So it's very much the style of mediation I'm talking about is very much a facilitative style where you are helping the parties to find a solution that is mutually acceptable. The other end of that is the evaluative style of mediation, where you actually tell the parties, as one famous Australian mediator did, he said, you're going to lose. And that's not my style of mediation, I have to say, although I recognize some people welcome that. So in 1994, I became a mediator, and it took about 5 years of running a legal practice and a mediation practice before I said, I really want to see if I can make a go of mediation. And of course, that was 24, 23 years ago. It's early days yet, but I think it's working. So that was how I came into mediation, and just I did a training with CEDA, Centre for Effective Dispute Resolution in London, which was a really excellent training. Indeed, the following, as soon as I'd done it, I was asked if I would then help train. And so I've been training mediators I did that for another 25 years and loved it. At the same time, my practice included criminal work as well as civil work, as is obvious from what I've said. And I began to think maybe there was a way that the principles of mediation could be applied in the criminal field, however counterintuitive that might seem. And so I started in my mind to construct some sort of mediative system between victims and offenders, not instead of the criminal justice system, but alongside it. And the whole thing was crystallized by a case that I had to pass sentence in. So by then I'd become a recorder, and I was sitting part-time as a Crown Court judge, and I had to sentence 4 young men in a robbery, a knife-point robbery, in which they had terrorized 2 ladies, older ladies, working in a travel agent in West End, as a matter of fact. And I had to sentence, they were under 21, so there were certain limits to what I could do. And it became clear to me that I was going to have to sentence them to imprisonment. And imprisonment meant, back then, and even more so now, putting them into an environment where they almost certainly weren't going to get rehabilitated, and almost certainly were going to get more skilled at the sorts of crimes that had got them there in the first place. And it was a prison governor around that time who described the prison as a university of crime. And I think that's a fair description, as anyone who's had contact with the criminal justice system may recognize. And in this robbery case, I thought, if only, so I heard the mitigation for each of these 4 young men, and each one was more tragic than the one before. They were kids who'd been abandoned, who'd been put into care, who had been abused by their carers in some cases, and had had an absolutely horrific childhood. And one can see, obviously, the origins of their aberrant behavior, their unacceptable behavior, their delinquent behavior. And so I thought, if only those two elderly ladies who had been terrorized heard that these kids were basically themselves victims. It doesn't excuse what they did, but at least they would understand. And I thought, if only these young men could hear the effect of what they'd done on the ladies. There was no such thing as an impact statement in those days, but there was, if only there was a way in which they could hear that. And sadly, I came to the conclusion there was no machinery to do it, and I had to pass sentence of youth custody, and that's what happened. But I was left feeling very, very dissatisfied with what I had had to do. And then I discovered that there was this thing that people were doing in little pockets across the country called restorative justice. And it started with victim offender mediation. It started with an opportunity for the victim, if they were willing, to sit with a facilitator, a trained facilitator, and the offender, and have an opportunity to dialogue. Not just an opportunity to dialogue, but anyone who's ever been the victim of an antisocial act or crime will know one of the things that you want to know is, why me? How could you do this to me? Do you realize the consequences of what you've done? Etc., etc. And the offender has the opportunity to say, it wasn't personal, however improbable that might seem, and you have to understand the circumstances that I was in, and there's this exchange and there's this opening out of what otherwise would simply be the crime and the punishment. So long story short, I kind of lent my weight, such as it was, to the then early days of restorative justice. And in 1998, I joined something called the Restorative Justice Consortium. One of my first tasks was to go to Lord Bingham, who was then the Master of the Rolls, or Lord Chief Justice, and explain to him what restorative justice was, to try to get some support. In fact, I discovered he knew more about it than I did. He was extremely well informed. Nevertheless, he was willing to help to support this infant restorative justice. And in due course, I became a board member, then chair of the Restorative Justice Consortium, which then became the Restorative Justice Council. And we managed to get the patronage of the Princess Royal, Princess Anne, who is still a patron of the RJC. And in 2013, just as I left, we saw the passing of the Crime and Courts Act of 2013, which actually provides explicitly for a restorative justice process if victim and offender want it, if they agree, because the voluntariness is a core feature. And that would allow, if such a thing was going to happen, the court would either adjourn to allow such a process, or it would defer sentence in order that that process could take place. So that legislative support was a huge boost to the restorative justice movement. The other two things were the government made £1 million grant, which was unheard of back in those days, to support the development of restorative justice, funding for the police, yachts, the youth offender teams, and prisons to do more of it. And the feather in the cap, or the icing on the cake, was the Daily Mail, which up till then had been publishing headlines like "Crooks get away with it by saying sorry," suddenly gave us a 2-page spread. I say us, gave a particular restorative justice process a 2-page spread supportive of restorative justice. And that was a huge turnaround. So that's basically where my career took me. I didn't know I was going in those directions. You only know these things when you look back and see, aha, so that's what happened. so on. But the other thing to say, just to bring things up to date, is I'm still mediating, and it's challenging, but it's hugely satisfying. And I do a lot of commercial cases. I also do cases against the police or within the police. I did a schools one last week involving a school, not Highgate, but with a conflict. Not that Highgate ever has conflicts, I know, but this school did. And more and more, my restorative justice work has focused on the environmental crisis in which we are, because I believe and know actually that there is a role for restorative processes where there has been environmental harm, where there have been victims of environmental harm, and there is the opportunity to have a dialogue between those who have caused the harm and those who have suffered from it. And we're talking, of course, about individuals, but increasingly the conversation is about the rights of nature and the rights of natural features to have a voice, whatever that means, in a restorative process. But in any event, the work that I'm doing now includes RJ, restorative justice, in environmental harm. And that's a particularly for me, rewarding area to work in, because of course, as many, if not all of you would agree, this is the crisis that we face at the moment. And if we don't address it, we're in deeper trouble than we even thought we were. So I think that's as much as I want to say. I'll add one other thing, which is that a particular area in environmental justice, restorative justice, is the proposed crime of ecocide. And as you may know, ecocide is proposed to be the 5th crime against peace. There are a number of nations, including the EU as well, and the Pope, and a variety of other people who have called for a crime of ecocide to be enacted, which would enable prosecutions of individuals, including those at the helm of major companies, multinationals, to be held responsible if their organization causes environmental harm, widespread environmental harm. So that's an area in which I'm working at the moment with others in a working group to put to the European Union draft legislation which would be adapted in individual countries in order to enable prosecutions of what you might call ecocide crimes. So that's perhaps too long an overview of what's brought me to today, but I welcome questions. And I can certainly say a bit more about how restorative justice works, if anyone would like to know.
I'm sure they would like to know. We've had a couple of questions submitted already and a few in advance. So we'll start with quite a broad brushstroke one. What makes a good mediator?
Not problem solving. One of the first things that most people do when they are trained as a mediator, or when they start to train as a mediator, is to want to solve the problem. You know, two people come to you, they say, here's the dispute. It's perfectly obvious what they need to do. And the temptation is that you want to tell them. And that's a big mistake. It's a big mistake because the parties need to construct their own resolution. The parties will almost certainly reject something that some outsider who doesn't know anything about the background will come along and tell them. They need to work through it themselves. And so not problem solving becomes a major shift from the way most of us are trained, which is we're trained to give people an answer to their question. And yet this is the very opposite. So that is at least an important quality for a mediator.
Interesting. We've had quite a few questions already about restorative justice. So one that could be quite interesting is, can restorative justice be applied to corporate cases or for cases with a large group of victims, for example, as an alternative to a class action lawsuit?
Good question. I don't know who asked that, but it's a great question. And it is something I've literally been working on today, which is the potential use of restorative justice in corporate crime. Now, one area of corporate crime is the environment and environmental harm. So clearly it can be used there, even though there will be a vast number of victims, or maybe a large number of victims. Part of the challenge of setting up a restorative dialogue is finding ways to narrow down to find representatives who can articulate on behalf of groups of victims, and there may be different groups of victims. So, as is common with other restorative justice cases, it's front-loaded. You've got to do a lot of work before you ever bring people together. Indeed, there may be circumstances in which you don't bring people together because it simply can't work. So another aspect of corporate crime is let's say the fraud, where there's been a Ponzi scheme, and Bernie Madoff is a classic example of it. Can you bring together the thousands of victims of Bernie Madoff? Well, not all in one room at one time, but you can find representatives who groups will trust, who will engage in the process. The subsidiary question is, would someone like Madoff, let me not personalize it, would someone who is essentially a sociopath, I mean, I don't know about Madoff, but I know that some of these people, defendants, are simply cut off from other people's feelings, from empathy. And the question is it appropriate for them to, even if they would, to join in a restorative process? And that's something which is being worked out now. We're feeling our way into it, and the work that I'm doing will result in a presentation at a university, actually the University of Antwerp, where we're going to explore exactly those questions. It's early days yet.
And is the UK sort of leading the field in this area, or can we learn from other countries?
I think so there are many, many indigenous cultures. In fact, I would guess every indigenous culture has at one time or another had a process for dealing with breaches of the law, let's call it, which don't involve a third-party adjudicator. So what we have in this country is a legal system where the state owns a criminal dispute, or the parties take their criminal dispute, their civil dispute, to a third-party judge or adjudicator who gives them a decision. Prior to this Western way of doing things, there was, I think, in just about every culture, a process where the whole community comes together to talk about a crime or a breach of convention. And that is, you know, that phrase about it takes a village to raise a child. Well, in a way, it takes a village to deal with a breach of the law. So then gradually that process has got eroded by our way of doing things, but it's come back through New Zealand and Australia, actually, the Maori and the Aborigines, who have, I won't say insisted on, but who have promoted this way of doing justice, and people have got hold of it. And they, I would say, are the leaders in the field in many ways. But in Europe, I would say that the UK has probably got there ahead of others, but there are others following.
And why do you think that is? Why do you think the UK is ahead of other European countries?
That's a good question. I have no idea. I think possibly because there are enough people in this country who recognize that what we've got, what we've had up till now doesn't work very well. I mean, here's the thing. You look at the statistics for recidivism, you look at what prison does in reducing reoffending, and the answer is not very much. You look at other ways of dealing with people, and they're a bit better than prison, but not much. I'm not saying people don't have to be sent to prison in some cases, but nothing like as much as we do. So when you actually look at what restorative justice does, the statistics that we had in the RJC, and I have to say they're qualified, is that something like 26%, there was a 26% reduction in reoffending through offenders who've gone through an RJ process. What is more, the victims reported something like an 85% satisfaction rating, having gone through a restorative process. Anyone who's gone through the criminal courts as a witness will know that you're likely to receive the mushroom treatment. I don't have to spell that out, but it's being kept in the dark, and you don't get a very satisfactory treatment. And the satisfaction ratings, as I remember, was something like 20%, less than 20%. So there's a massive increase in victim satisfaction, and people talk about their ability to achieve closure, their ability to undo some of the trauma that people experience when they're the victims.
That makes sense. A final question on restorative justice, and then we've got quite a few questions about Ecocide. Yeah. So we've got a few questions that I think can all be kind of summed up in one, which is, does restorative justice work for everything? Would it work for an extremely serious crime, or is it only kind of more minor crimes?
It certainly works for serious crimes, and I'm thinking about, well, everything up to murder, actually, but let me put it in context. So there are a large number of accounts, and I would refer you to the Forgiveness Project for a good summary of some of this work. But there are a large number of people who have suffered the loss of a loved one or a relative or someone that they were close to because of murder or manslaughter, and they've had restorative meetings with the offender. Now, that's not to say that the offender is going to walk out of court scot-free, because they have, in fact, it's usually after sentence when he or possibly she is serving out a long sentence, and they agree to have a meeting with the victim. So there are those, but there are also cases, for example, of domestic violence, where it's much more challenging to have a restorative process, partly because in any restorative process, the prime consideration is that the victim is not re-victimized, that the victim doesn't have something overlaid on what they've already suffered to make it worse, which is why I say that you don't bring them together until they're ready to meet. But in that case, one would need to be extremely careful. And there are restorative justice facilitators who are trained in domestic violence, who do those sorts of cases. So is it relevant? Is it appropriate in every case? Well, as long as both victim and offender agree, as long as I think the facilitator has some sense that it might work. And that takes me back to the sociopathic offender. Is it appropriate to have it in those circumstances? I would say not. But you don't know until you explore it. And you never know when people reach that moment in their lives when they say, I'm talking about offenders, I'm wasting my life here. I want to make a clean start. And that is often the moment when a restorative justice intervention can transform someone's attitudes.
Yeah, and I guess a person can change quite a lot in the time between committing a crime and entering the restorative justice process. I'm going to go back on my word and ask one more question about restorative justice, and this is from a former Westgate contemporary of yours. Who pays the mediators in a restorative justice process?
I should have expected that from a Westgate alumnus. Where does the money go? Who pays the mediator in restorative justice? Well, the sort of funding that I've been talking about. The government's made available various funding. Some people do it as volunteers. Often there is a local community mediation service that will do it for modest fees. If anyone's thinking that it's a good career choice, I tell you now, you better have another source of income. You better have a day job, because RJ is not going to, there are fees around, but it's not big money.
Good note of caution. So moving on to ecocide, do you think the crime of ecocide would be more effective in tackling climate change than, for example, civil lawsuits?
Well, that is just someone's put their finger on one of the issues at the moment, which is, should it be just a criminal offence? Should it be a civil offence? You know, one of the problems with anything called restorative justice is that you are on the receiving end of some sort of justice process. So you're already on the back foot, as it were, even though it's not like a trial in court. And I find myself regularly having to reframe it as a restorative process rather than a restorative justice process. And one of the prerequisites is that people admit their guilt before they go into the process. But I have had some where guilt hasn't been admitted, probably not a crime, but some antisocial behavior. But would it benefit from having civil remedies? Yes, I think it would. And that is actually part of the discussion that we're having at the moment, is whether it can be made a civil remedy, a civil offence as well, so that all the remedies of the civil court can be brought into play.
And do you think that's likely to happen?
Well, given time, yes, I do think it's likely to happen. I think there's a real groundswell of opinion. Look, over the last 5 years, I've seen a massive shift in public awareness of the environmental and climate crisis that we're in. 5 years ago, people were talking about it a bit. I mean, I've been banging on about it for rather longer, but I think that there is an increasing degree of urgency that people feel and want to do something that will change behavior. And that, I think, leads me to think that in the next 5 years, the crime of ecocide will be on the statute books.
Interesting, very interesting. Somebody has asked, can you talk about any standout environmental cases that you've worked on or you're working on at the moment?
Yeah, has to be anonymized, you will understand, because it's a live issue. I'm just wondering whether I talk about one thing or another, but let me talk about one thing. There's an African nation that has been the subject of oil extraction for the last approximately 50 years. And they have been seeking redress through the courts in one form or another. And recently, I mean, this year, they approached me to ask if I could facilitate a dialogue between them and the oil company, or the major oil company, that was causing the harm in their country. And I agreed to do that. And we have so far only online. We've had a series of meetings, which so far is resulting in the likely installation of solar mini grids. That is to say, sustainable energy, solar PV energy that is available at low cost to communities throughout certain parts of this African nation. And it's happening, and it's come through a restorative dialogue. And it started as a rather accusatorial process, but it has become a collaborative process where the participants are working together to make this happen. So that's a current example of how this might work.
It's really interesting. I feel quite privileged to know that that's going on. We have 3 more questions for you. So the first one is, what role is technology playing in your work?
Well, I would have, if you'd asked me the question 2 years ago, I'd have said none. We've got computers. We keep our papers on computers. Actually, that was a big shift for me, not getting papers in paper form, but having them online, on the computer. So I creaked into the 21st century with that one. And then, of course, came lockdown and getting to grips with Zoom. And the answer is that technology now plays probably, 60% of my mediations are online at the moment. But that number is shrinking as people get back into in-person meetings. But actually, it's really rather convenient. I like it. I like the idea that my journey to work is from the bedroom to the front room. That I can go off and have a cup of tea when the parties are deliberating about whether they'll accept the offer or not. And it's it's actually a lot more convenient. But I'm just trying to think, maybe there are more sophisticated uses of technology that I'm not thinking about. What else is there? No, it's principally Zoom and to some extent Teams, which I'm not so crazy about for mediation purposes, but those are the main areas that I can think of.
And as well as being convenient, do you think it's as effective on Zoom? Do you get as good a sense of,
Well, I can answer that in this way, yes and no. Or to put it another way, it depends. So I think one of the advantages of it is that where you've got a very adversarial atmosphere, at the beginning, people are antagonistic towards one another. I think there's some advantage in having them on a screen rather than sitting eyeball to eyeball, not that I'd have it like that, but sitting across a table from one another. I think there may be some advantages in that respect. But the disadvantage is the disadvantage that we must all have felt during lockdown, which is you're not in the room with the individuals. Apart from the fact you can't read them, you miss the subtleties of body language and non-verbal communication, but also you're just not with them. And so there's less of an engagement, I think. My training work, one of the things that I did was to train, in fact, it was train mediators in Denmark, which I did from this room. And I did a 3-day training from here, which without technology could not have happened. But my goodness, getting back there and getting back into the room with people, it's a step change.
I think most of us can probably agree to that one. Yes, really. Definitely. So 2 final questions. This one is a bit of a curveball. Do you believe in prison reform? And if so, what would that look like?
Do I believe in prison reform?
Reform.
And what would it look like? Yes, of course I believe. Of course I believe in prison reform. What it would look like is less overcrowding, more stimulation, more rehabilitation, learning useful skills, getting paid modest amounts for it, not being banged up 23 hours a day. There are a million things, but it all requires resources. And it requires also the imagination not to send people to prison, but that's scary. And I can speak as a judge. You've got the tabloids looking over your one shoulder. You've got the Court of Appeal looking over the other shoulder. And you've got the public out there who on the face of it will be outraged if a hard sentence is not given for a hard crime. Of course, what you discover is that when you actually talk to people and they start to unpack a criminal event, their desire to see that sort of punishment changes. But so prison reform, yes, great. who's going to do that?
Interesting. And that sort of leads on to our final question. When you think about the future of the justice system, are you optimistic or are you pessimistic?
Well, in the short term, I'm pessimistic. I really am. I mean, the way that the law has been de-resourced, the way that, I mean, it costs barristers and it probably costs solicitors, I don't know, more sometimes to go to court and do a case than they earn. Well, there's something, talk about negative equity, there's something deeply troubling about that. And I noticed that my colleagues, my former colleagues, were out on strike in the streets yesterday, I think it was. So I think things are really bad. And the tragedy is that it's such short-termism that people, government doesn't realize. It was, I think, Mr. Grayling who launched this attack on the bar, that doesn't realize that it's us, the people, who suffer, because if we haven't got a decent working legal system, the rule of law starts to get eroded, which is absolutely one of the pillars of our democracy, as I see it. Longer term, if we get through this, if the planet is not yet consumed by fire and floods, I do think, I mean, if we're talking really quite a lot time into the future, yes, I think that there is room for a much more restorative legal system. And I hope that, I mean, apart from anything else, Harry Wolff, the Lord Chief Justice in 1999, changed the civil procedure rules so that mediation becomes the first stop rather than litigation being the first stop. So that was a huge shift. And when that actually seeps into the legal system as a whole, I think that you'll see much more dispute resolution by dialogue, both in the civil and in the criminal field. I think that the judges will be more interested in restorative approaches rather than just punitive. And I think, you know, the friend who introduced me to mediation said, and when the legal system changes, Parliament will change. And I said, well, how can that be? Because Parliament's set up to be adversarial. And I don't know about you, but I see so much energy that's wasted in that process. He said, because there are a lot of lawyers in Parliament, and when the law and lawyers start to get there are better ways of doing this, then the adversarial political system will start to shift as well and become more of a collaborative problem-solving approach to the issues that we face. So long term, probably long after I've gone, but if there are young lawyers and would-be lawyers who are listening to this, the ball's going to be in your hands to make this happen.
And I think that is a brilliant optimistic note to end on. Thank you so much, Lawrence. And I'll now hand over to our OC President, Richard Brewster.
Hello, everybody. I'm delighted to be able to say hello on behalf of all of the guests, and in terms of speaking on behalf of the OC Society, I want to extend a massive thank you to Lawrence for what has been a fascinating, we could have gone on for ages, Emily. Lawrence, you would have been quite exhausted, I think, if we'd taken all the questions that were coming into people's minds. I mean, in the end, we were getting into the subject of the government of the country, which is an even bigger subject than you started on. I think I speak for all of us in wanting to thank Lawrence for giving so much time, speaking in such a fascinating way on such a profound subject. So thank you very much, Lawrence. Being on Zoom, we don't have quite the clapping facility we would if we were all in the same room. But anyway, a huge thank you. The other party that I must thank on behalf of everybody who is an audience and has benefited from this, of course, is the Development Office, who've put together this event for us, which is wonderful. The Development Office organised the events on behalf of the OC Society. Thank you so much, Emily, and your team for doing that. Wonderful. I also think a word of thanks for those excellent questions, really good questions, right going to the heart of the issue. And in fact, I think Lawrence was quite impressed himself by it, and he'll tell me later. But I think, I know there were lots more that we could have asked, but terrific stuff. Thank you so much. And finally, of course, a big thank you to all of you who attended. Without the audience which we've got, which is a good audience, thank goodness, I don't think we'd have an event at all. So well done, all of you, and I hope you'll be back for future OC events. Please keep a watch out for them. I'm hoping that it won't always be online, because I have to say I do agree with Lawrence's thought that you do need to actually have a bit of human interaction from time to time. But we will, I think, have online as well as face-to-face. So please keep an open eye on future events. That leaves me really with only one thing to say, and wish you all a very happy evening. Thanks so much for attending. Bye.